Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. We have some breaking news for you out of Boise, Idaho, regarding the federal lawsuit styled as Rebecca Schofield versus Ashley Guillard, which we have been referring to as the Idaho 4 defamation case. 24 hours ago, there were questions as to whether the defense had abandoned this case, whether this matter might be going to jury trial as scheduled on February 24th for a 4-day proceeding, as possibly an empty seat situation with just the plaintiff appearing before the jury. Well, what a difference 24 hours has made. There is a new entry on the court docket, and it is an order that has been rendered by the federal court following the pretrial conference, which we had reported to you had been set for several months to occur yesterday at 10 a.m. Document entry number 118, dated the 5th of February, 2026, if you would like to take a look at it. It is entitled Order, and it reads as follows. Following today's conference, the court hereby orders the following. Number 1, defendant shall file her motion for continuance on or before February 6th, 2026. 2, plaintiff shall respond to defendant's anticipated motion for continuance and defendant's motion to dismiss by February 12th, 2026, and defendant shall file any replies in support of defendant's motion for continuance and motion to dismiss by February 13th, 2026. Signed by U.S. Magistrate Judge Raymond E. Patricchio. Ladies and gentlemen, there's a lot going on in this court order. First and foremost, we see a very abbreviated schedule regarding the briefings and the time frame that the judge wants the parties to file their respective papers. And this, in my opinion, is due to the fact that there were some developments that happened yesterday, the 5th, that has put the potential for this jury trial commencing on time that has been set since August 12th, 2025, 4-day jury trial scheduled to begin Tuesday, February 24th, 2026, beginning at 9 a.m. in jeopardy. As we had reported to you yesterday, the defense filed a motion to dismiss for lack of subject matter jurisdiction. This is challenging whether the federal court had ever jurisdiction, the authority to entertain this proceeding and enter enforceable orders or not. Federal courts are courts of limited jurisdiction, whereas state courts are courts of general jurisdiction. And you will see in appeals, for example, the appellate courts will say we have to make sure we have jurisdiction over this matter, that we are not overstepping our bounds into something, for example, that the state court should have entertained. That's what she's arguing, the defense. This filing yesterday, if you look at it, it's the prior docket entry, 117. There were automatic timeframes for a response that was due on February 26th, 2026. A problem because that would have been day 3 of the jury trial. So we see here where the judge has entered an abbreviated time frame schedule. He wants everything in by February 13th, 2026, prior to the start of the scheduled jury trial. Now let's look at the first item. The defendant shall file her motion for continuance on or before February 6th, 2026. It appears that what Ms. Guillard did at this hearing yesterday, final pretrial conference, was say that she was going to be filing a motion for continuance. Judge has said now, you will get this written motion in today, the 6th of February, and then directing attention toward plaintiff. Plaintiff, you will respond to this anticipated, because it had not yet been filed as of the 5th, but the anticipated motion for continuance and the motion to dismiss by February 12th, 2026. And then any replies from the defense need to be in by February 13th, 2026. So there's two matters here that the court's anticipating he's going to have to rule on. One, the motion to dismiss to see if this case should even proceed or if it should be kicked out of federal court and ended due to a lack of subject matter jurisdiction. That remains to be seen. And secondly, as to this pending motion for continuance of what? This has to be for the trial because of the forthcoming trial date in less than 3 weeks' time. The briefings go motion, response, reply. So he's anticipating, hey, if defense is going to be filing a reply to the response to the motion to dismiss and or a motion for continuance, you have, Ms. Guillard, up to and including February 13th, 2026. And it appears because the judge is wanting to get all papers in for his consideration before he decides whether to toss this case out of federal court altogether or to postpone the trial. We will continue to keep you posted regarding the Idaho 4 defamation case. It's called that because of the close association to the catastrophic events that occurred at 1122 King Road. Plaintiff Schofield is a history professor at the University of Idaho. The defendant is an online content creator and a psychic. The plaintiff alleges that the defendant defamed her in two separate ways. There's two claims, two counts. Count one alleges she was defamed by content that was published allegedly by the defense that stated she had involvement in the crimes that occurred at 1122 King Road. Count two, second claim for defamation. Plaintiff alleges that defendant further defamed her by publicly stating that she had had a relationship with one of the students. Plaintiff has vigorously denied all of these claims. The defense has vigorously denied that she engaged in any defamation. The court back in 2024 issued an order in favor of the plaintiff. It is a motion for partial summary judgment, finding liability. The only issue that is pending before this jury, if trial commences on the 24th of February as scheduled all these months, or if it's continued, will be damages and damages only, nothing else related to defamation or liability. The court has ordered will be before this jury. What, if any, amount of damages should be awarded to plaintiffs? Until next time, this is Kathy. Thank you for joining us here today.